Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey guys, I hope you are having an amazing and productive Wednesday. Almost forgot what day it was. But I wanted to update you guys in regards to the Shanquella Robinson's case. If you are unfamiliar with this case, this is the case where her life was taken in Mexico while on I believe it was a birthday trip to be more precise. But if you've been hearing about the Cabo Six, we have pretty much been trying to get justice for her untimely death, and it just seems like it's not going in that direction. They initially filed, and when I say they, her family, actually her mother filed a lawsuit in a superior court in North Carolina, but because there's the U.S. Department of State as well as the Federal Bureau of Investigation. You can't they The state court does not have jurisdiction over federal entities, therefore they had to transfer it to the federal court. With that being said, with that being said, now Elise White or Height, I believe that's how you say her name, and Winter Donovan are moving. They are moving to get this case dismissed, or at least themselves dismissed from this. Before I start reading the actual motion to dismiss, there is a term that they are going to use as far as the reason why it's being dismissed, and it is improper venue. um, and pursuant to forum non-convenience. And what that means is it refers to a situation where even though a court technically has jurisdiction to hear a case based on the parties involved and the subject matter, the chosen venue is considered inconvenient or inappropriate due to factors like where the events giving rise to the lawsuit occurred, or the location of key witnesses, and the overall ease of access to evidence, making another forum significantly more suitable for the case to be heard. Then it goes on to say essentially, the current case is not the most convenient place to litigate the dispute, following a defendant to request dismissal under the forum non convenience doctrine to move the case to a more appropriate venue. Yes, this is what they're trying to do. Let's get into the actual notice and the memorandum to actually support. So they did hire an attorney, because that's what they submitted their requests previously, to give them enough time to find an attorney so that the attorney can respond appropriately to the lawsuit. And so on February 21st, both Elise and Winter, through their counsel, files a contemporaneously herein memorandum in support on this motion to dismiss the improper venue. Um, let's just get into this because it's going to make more sense. So, this is their reasoning as to why they are wanting and requesting the court to dismiss this action. Plaintiffs filed the North Carolina State Court complaint that initiated this particular civil action on October 28, 2024. Defendants, Federal Bureau of Investigation, and the United States Department of State chose to remove the matter to this court on November 14, 2024. Defendants Winter Donovan and Elise White, now moves to have the claims against them pursuant to Rule 12b3 of the Federal Rules Procedure for improper venue under the doctrine of forum non-convenience. Here are the facts. Plaintiff's actions has various legal theories against bystanders. That's what they're calling themselves, bystanders, Winter and Elise, arising out of a fight between two of the travel companions on a trip to Cabo San Lucas, Mexico on or about October 29, 2022. The deceased, Miss Robertson, died in the hours following the fight. There is no allegation that defendant Donovan, or Height participated in the fight or touched anyone. Various individuals who all reside in Mexico participated in the treatment of the deceased, including doctors and hotel personnel, each of which are the critical witnesses to support plaintiff's theory, and that these defendants had a duty to act and negligently perform that duty. Their testimony would be an essential part of any trial of the action. The claims occurred in Mexico and would be governed by Mexico law. Mexico has a civil justice system. To these defendants' knowledge, no claim has yet been filed in Mexico. This is so sad because it is a lot of back and forth. The FBI failed them, the U.S. Department of State failed them. For the simple fact, the Mexican authorities issued a warrant. They submitted all the paperwork, I believe, to the U.S. Department of State. Question presented. By their motion, plaintiffs presents the following question to the court. Should the court dismiss the claims against Donovan and Height for improper venue pursuant to the doctrine of forum non-convenience? Here's their argument. The U.S. Supreme Court relatively recently clarified that a federal district court ought dismiss claims in an action on the grounds that a court abroad is the more appropriate and convenient forum for adjudicating the controversy. They cited Sino, Sinochem International Company versus Malaysia International Shipping Court. And in that case, the civil dispute revolved around a dispute involving a boat in which the operative facts arose in China. The holding was that the district court could dismiss the action at the outset, even before evaluating personal and subject matter jurisdiction. They also cited Gulf Oil Corp versus Gilbert, where Justice Jackson describes some of the multifarious factors relevant to the forum nonconvenience determination. An interest to be considered, and the one likely to be most pressed, is the private interest of the litigant. Important considerations are the relevant ease of access to sources of proof, availability of compulsory process for attendance of unwilling, and the cost of obtaining attendance of willing witnesses. Possibility of view in premises, if view would be appropriate to the action, and all other practical problems that make the trial of a case easy, expeditious, and inexpensive. There may also be questions as to the enforceability of a judgment if one is obtained. Factors of public interest also have a place in applying the doctrine. Administrative difficulties follow for courts when litigation is piled up in congested centers instead of being handled at its origin. Jury duty is a burden that ought not to be imposed upon the people of the community, which has no relation to the litigation. In case which touch the affairs of many persons, there is a reason for holding the trial in their view and reach rather than in remote parts of the country where they can learn of it by report only. There is a local interest in having localized controversies decided at home. There is an appropriateness too in having the trial of a diversity case in a forum that is at home with the state law that must govern the case rather than having a court in some other forum untangle problems and conflict of law and in law forum itself. Oh my gosh. So if if they have any type of trial in a foreign country, that's not beneficial to the plaintiff or anybody, any party in this case. If they have the trial here or just a case in general, like this case, if they have the litigation case here and it proceeds to trial, it is not beneficial because the key witnesses, who were the doctors and other people in Mexico, it would be too much money to get them to come over here and stand trial, or get them to come over here to be deposed, because y'all know the process. You go through discovery, then depositions, and at that time you don't really need any witnesses for mediation, but definitely during discovery. So they might be sent. Well, they're not even part of the lawsuit, so we don't have to worry about them, answering any discovery. But when it comes to depositions, they might be deposed because they were the ones there. And it will cost too much money just to send for them to come here, get deposed, go back home. And if trial starts, no, you have to think about the cost. And so that's what they're saying, is it's not beneficial. So it's like you're stuck between a rock and a hard place with this particular one. From the concept that I just read, the Supreme Court in Kim decided and held that the government of Malaysia's international complaint, misrepresentation of the Guangzhou Admiralty Court, different, that's very different, in the course of securing arrest on a vessel in China, is an issue best left for the determination by the Chinese courts. As such, the case was dismissed pursuant to the Rule 12b-3 at the outset of the litigation. Here, too, the gravamen of the complaint surrounds interactions with hotel workers and doctors that are all located in Mexico. Further, the parties were all in Mexico, and the applicable claims against Donovan and Haidt directly involve Mexican tort law and theories of, among others, civil negligence, contributory and comparative negligence, bystander duties, medical treatment, all of which will be determined by the laws of Mexico. Here in the Western District of North Carolina, defendants Donovan and Haidt have no ability to obtain the testimony of the applicable witnesses to present a fair defense for the court and jury to determine the issues on the merits. Further, a court in Mexico is in a significant better position to evaluate and apply the laws of the jurisdiction to the alleged facts in this dispute. By any measure, this case ought be decided by a civil court in Mexico. In conclusion, for the reasons stated herein, the undersigned respectfully moves the court for an order allowing jurisdictional discovery as outlined herein. There we have it. I mean, there's not too much to say about this. Um, I just feel like we're going around in circles. The FBI is saying they didn't do anything wrong. The US Department is saying they didn't do anything wrong. We have read that the Mexican authorities wanted to get specifically Dejanay Jackson and arrest her. They sent all of the paperwork to the US Department of State, and the US Department of State did not do anything. Who is to blame here? And I must admit, their attorney did state case law in reference to a case which was dismissed because of this. So is somebody going to work with the Mexican authorities to ensure, because as of right now, Dejanay has, or is that her name? Dejanay, I think it is. She hasn't even been served yet. There are still two individuals who have not been served in this case. So I do believe that if possible, the US would need to work with Mexico to ensure that there's some type of justice that is done. And this is just really a slap in the mother's face at this point. Everybody's, shifting the blame. But I do understand the legalities of this and the process, and they're right. But who is going to pick the ball up and say, I'm claiming it. This is the game plan. This is what we need to do in order to ensure that this litigation case proceeds. Y'all let me know what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.